Okay, this is Stefan Kinsella. I'm just going to do a quick little narration here of some of the proposals I made. As everyone knows, I'm against patent and copyright. I'm a patent attorney, by the way, and a libertarian theorist. I've written for over 25 years on problems with the patent and copyright and other IP laws. And I proposed some improvements that could be made to the existing patent and copyright and other IP laws, short of abolition. They would greatly reduce the harm done by these laws. Of course, they should be abolished, but I proposed, for people that don't understand these arcane systems, I proposed various changes that could be made. And in a tweet, Mr. Sanjeev Sablok is writing some kind of book where he's proposing some changes, and he took some of my ideas, but he has question marks by some of them on the tweet. So I'm just going to read through some of the things I have here. They're not in any particular order, although some are more important than others. So let me just go through them real quick. And in my writing, I explain what these are. Some of them are details and specialty areas that only patent attorneys would know, and I can elaborate on those, and I've written on those in my writing. But okay, number one, the first thing to do would be for patent law, for reforms to patent law, the most important thing would be to reduce the term. The term right now it used to be 14 years in the beginning of the country. Now it's about, and then it changed to 17 years from the date of issuance, which means you file a patent application, and then you prosecute it. That's called prosecution. People like me go back and forth with the patent office until it's prosecuted, and they prosecute it until it's issued, if it issues. And then you would have 17 years term after that. That would be extended sometimes for pharmaceutical patents if there was a delay from the FDA, but basically it was 17 years. About 15 years ago, the U.S. switched to the system most of the other countries use, which is instead of the first to file system, instead of the first to invent system, it was a first to file system. So now that was changed so that if there's a dispute between two people who have a similar idea, the one who filed first wins. And so that's one change that was made. A lot of patent lawyers made noise that that's a big deal, and even Ayn Rand mistakenly thought that was a system at the time she wrote in favor of patents, and she wrote these arguments trying to justify that. But she was justifying a system that didn't exist. But now it does exist. Now in the U.S., patents are issued, and the one who is the first one to file a patent on an invention that they invented means you can't copy someone else's idea and file a patent on it. But if you're an independent inventor, the first one to file, you get the patent, and then the term is from the date the patent issues until 20 years from the date you filed. So if I file on day one and it takes 3 years to prosecute it, and then it issues, there's 17 years left. If it takes 2 years to issue, there's 18 years left. If it takes 5 years to prosecute it, which is rare, it would have 15 years of term. So the term is now approximately 18 to 17 years from the date of filing, starting on the date of issuance. So that's how the patent works. So one improvement that could be made, as my list of proposals points out, is reducing the term to a lower number. So instead of going from 17 years on average, which is again 20 years from the date of filing, it should go to a lower number, like say 5 years from the date of issuance. So a 5-year patent term would do much less harm. So that would be the first thing, reduce the patent term. And Mr. Sablok proposes 2 years, which would be fantastic. There's no way that would get past people that are rabid supporters of patents, but that would be an improvement. The lower, the better. The next thing I say is remove patent injunctions and provide compulsory royalties. That is under compulsory licensing. In other words, there should be no right to get an injunction to stop someone from using a patented invention, but they would have to pay royalties. This would reduce the amount of competition that is dissuaded by a patent. Right now, if a dominant player gets a patent, and by the way, everyone thinks that bad patents issued by incompetent examiners that don't take into account all the relevant prior art or the problem, or that patent trolls, which are called non-practicing entities, are the problem. But they're actually the least of the problem, because a bad patent can be ignored or fought in court and usually defeated. So they don't reduce competition or pose as much of a threat against competition as a good patent does. A good patent means a patent that is hard to overturn. Hard to overturn. And then the second problem is that if a practicing entity, like say Apple, gets a patent, they can use that to stop competition, to prevent their competitors from competing with them with an injunction. Now, it is harder to get an injunction now because of recent changes in patent law in the last 5 or 10 years, which is a good thing, but that should be eliminated altogether. There should be no right to get an injunction at all. Instead, the competitor should have to be forced to pay royalties to the patent holder. That would at least allow competition, even though it would be at a tax. But it would be better than the current system. And then the alternative thing is the federal government, as the grantor of the patents, has the right under statutes right now to issue a compulsory license, which means the federal government can authorize competitors to use the patented invention as long as they pay some kind of royalties to the patent holder. So that would be another improvement. Another would be putting a cap on the amount of royalties. That is, they should not be outrageous or unreasonable. My fourth proposal would be to reduce the scope of patentable subject matter, which means some things that are covered by patents should not be covered by patents. So, for example, books are covered by copyright. They're not covered by patents now, and they shouldn't be. But there are other things that used to not be covered by patents, like business methods and certain software, which should not be covered by patents. They should be outside the scope of subject matter under Section 101 of the Patent Act. So reducing the scope of what patents cover, the types of inventions that patents cover, should be reduced. Another is to provide a prior use and independent inventor defense. Now, that was introduced a little bit in the Obama American Invents Act, so there is some limited protection right now for anyone who independently invents an idea. They didn't copy it from the patent. They didn't even know about the patent that was issued. In that case, they should be able to, if they independently came up with the same idea, they should be able to keep using it without having to pay royalties or be subject to an injunction. That should be also another patch to patent law. Another one would be to instantly publish all patent applications to put people on notice. Right now, if you file a patent during the prosecution phase, it's secret for 18 months. It should be published instantly. There's no reason it shouldn't be published instantly. If you're going to seek a government monopoly, you should have to put people on notice as soon as possible that there's a potential threat to their business, and they should be able to take that into account in deciding whether they want to gear up to produce something that they independently invented without knowing later that they would have to shut down or have to pay a license fee or royalty fee. This used to be called the submarine patent problem, which was somewhat fixed by the Obamacare, by going to a first to file system, but still that should be added to patent law to reduce the harm that's done by it. Another one would be eliminate enhanced damages. Enhanced damages means normally if you infringe a patent or if you have to pay a royalty or to get a license, you have to pay if it's willful infringement. That is, if you're aware of the other patent when you started infringing or started selling a product that is too similar to the claimed invention in someone else's patent, then you can be sued not only for actual damages, whatever that is, which means you're competing with people, which we libertarians used to be in favor of, free markets and competition. But anyway, the damages ought to be only actual damages suffered by, that is, lost profits or something like that, lost by the patent holder, but that they can be expanded up to treble damages if there's willful infringement. That should be eliminated. There should only be actual damages. By the way, the same thing in copyright. In copyright, there's what's called statutory damages, So instead of proving that you suffered an actual monetary loss because of someone copying your work and violating your copyright, there are statutory damages, which I believe violate the Fifth Amendment and the Fourth Amendment, because and the Eighth Amendment, because the damages are unconstitutionally high. They have no relationship to the actual damage suffered, the loss suffered. So statutory damages in copyright should be eliminated. And also enhanced damages for patents should be eliminated. Adding a working requirement or reduction to practice requirement should be added to patent law, which means you can't just see. The way it works now is most people think that you have to invent something, come up with it in your head, and then reduce it to practice by coming up with a working model to prove that it works and to prove that you're going to sell it so that you actually suffer damages if someone competes with you. But the way it works now is you hire a patent attorney to write a patent description, a detailed description that explains how it works with drawings and examples and claims that define the invention. And you have a patent attorney like me file it with the patent office. And that is called a constructive reduction to practice. So instead of having to produce a working model, you just file a piece of paper that explains the invention, which allows you to make any claim you want, and they can be false. You can claim that your invention does wonderful things, but it could be false. In fact, many people have filed patent applications for perpetual motion machines, which don't work at all, which means they violate the utility requirement. To get a patent, you have to satisfy 4 requirements in the patent law. One of them is it has to be statutory subject matter, like the type of thing that patents are for. So it covers inventions and processes and compounds, but not artistic works or things that are covered by trademark law. Those are covered by copyright and trademark law. So Section 101 on what patents cover should be amended, but also it has to have utility. It has to be useful, which means it can't be something that doesn't work, like a perpetual motion machine. But it also I think you should have to produce a working model of it to prove that it works. That is statutory constructive reduction to practice by filing a patent application should not be sufficient. So we should eliminate that. That would also reduce the harm, because then you would actually have to put time and effort into producing a working model to prove that it works. So then it would be harder to file a patent on an invention if you haven't produced a working model. Under the law, the patent office has the right to ask the applicant for a patent to produce a working model. But in my 30 plus years of experience, I've never had the patent office ask me for that. So I think they rarely do it. Instead of having the right to do it, it should be required, I believe. Provide for advisory opinion panels. There should be a cheap, easy way to get a second opinion. And I think there's some procedure like that now since the Obama Act, which does make it a little bit easier to challenge patents. But it should be easier to not have to go to court and hire attorneys, but just have a second panel look at it and look at an issued patent. And the reason is because when a patent is issued, it has a presumption of validity, which means there's a presumption that the examiners, the patent office examiners, knew what they were doing and didn't make a mistake. They're often incompetent, and the prior art they're looking at is often incomplete, and so they issue patents that should not be issued. So it should be easier to challenge that. Also, it would be good to adopt a rule which I call the losing patentee pays, which means if you ever assert a patent against an innocent victim and you accuse them of patent infringement and you demand that they stop selling their product under the threat of an injunction, which should be abolished, or under the threat of collecting damages, which can be enhanced, which should be abolished, but even statutory damages, I think if you go after someone in court or make a threat that you're going to assert your patent against an innocent person, that if you lose in court, you should have to pay all the attorney's fees of the losing side. That would also reduce the harm, because right now, someone who holds a patent, whether they're a patent troll, so-called non-practicing entity, or a practicing entity, They can sue you, cause you to hire an attorney, which might cost millions of dollars. And even if you win, then you're just out the millions of dollars, which means large companies can threaten small companies or independent inventors not to infringe the patent, even if the patent is weak and could be overturned in trial if the defendant could afford to do it, but they can't afford to do it. So I think that anyone filing a patent infringement claim should have to put a large deposit with the court and be prepared to pay all the attorney's fees and damages suffered by the prevailing defendant if the patentee loses. That would be another good improvement. Another would be to get rid of the jurisdiction of I think it's the ITC. In other words, you should only be able to sue for patent infringement in federal court, not go to the ITC and stop imports, because that's another federal judicial remedy, quasi-judicial remedy that you can get, which is an alternative way of stopping imports, which can be used, again, as a threat against an alleged infringer to make them stop competing with you. So it should just have to go through federal courts only with Article III judges. There are some other things I mentioned, like the reverse doctrine of equivalence, which is sort of arcane to most people, but that should be added too. The filing fees should be increased to deter people from filing patents, and the maintenance fees, every 3.5 years you have to pay an increasing maintenance fee to keep these patents, which are issued by the government, on the books and keep them from being abandoned. Those fees should be increased. If you have a worthwhile invention that you're selling a working product, you should have enough resources to file to keep the patent alive. If you can't do that, then the patent should be abandoned and the invention should be considered public domain. And other requirements like you should have to require the patent applicant in the application to identify exactly what part is new, what part is old. Right now, you can mix them all together in the claims, and you don't have to say which part is new and which part is old. You should also have to require them to get a search done, which is not required now, by a patent searcher, and have an opinion by an attorney who gives an opinion saying that it does satisfy the requirements of the patent statute, which is novelty, statutory subject matter, non-obviousness, and usefulness, utility. You should have to have that before you seek to get the government grant you a patent, which can be used to deter competition. You should have to go through those steps. The number of claims should be limited. I think it should be limited to 1 claim per patent, at most 20. Right now, the limit is 20 unless you pay extra. I don't think you should be able to pay extra, because the more claims you have, the more expensive it is for someone accused of infringement to hire an attorney to decide whether they're infringing or not. If you have 20 or 100 claims in a patent to go through, it just multiplies the cost and the uncertainty. So 1 claim per patent, which identifies what is new and what is not new. Limit the number of continuations. Right now, people can keep, if your patent comes to an end because you keep getting rejections from the patent office, you can just file a continuation. You should be limited in that ability. You should get 1 or 2 bites at the apple, and that's it. And the presumption of validity should be abolished. In some countries, there are petty patent systems and systems where you file a patent, but it's not examined by the patent office, and the patent that you're issued has very little presumption of validity. So the threat against the people that are accused of infringing is much lower in that case. And I think that would be an improvement, because the patent office is often incompetent anyway, and there's no reason an examination by a patent office should come with a presumption of validity. So patents should be just filed and just recorded, just like a copyright is now. Just because you tell the copyright office, you file a registration of a copyright with the copyright office, and you get a registration from the copyright office, it doesn't prove that you were telling the truth, or that you really are the author of the work, or that it's original. It's just a formality, which means it's less of a threat to people. One other change would be to apportion damages proportional to the value of the patent that is claimed. And that would be helped if you made the other change above that I suggested, which is having to force the applicant to identify in the patent claims and in the patent application which parts of their so-called invention are new and which parts are old. In other words, is it like 90% old knowledge which you added a minor improvement to, or is it like 10% old stuff and 90% new stuff? You should have to identify that, and then you should be held to what you claim, because if you say that, okay, it's 50% new, 50% old, and it turns out that you only have a minor improvement, then your patent should be invalid. So all these would be great improvements to the patent system. For copyright, again, reduce the term. It used to be 14 years at the beginning of the country, and you could double it by request one more time to 28 years. Over time, that is expanded to where now it's the term of a copyright is not 14 years or even 28 years. It's the life of the author plus 70 years. It used to be life of the author plus 50. Now it's the life of the author plus 70. So if you get a copyright on something when you're 30 years old and you live another 50 years, and then the copyright would last for 50 years plus 70 years. That's 120 years of term, which is absurd. Copyright terms should also be reduced to a lower number, 14 years, or preferably, like patents, 5 years or 2 years, something like that. Copyright used to not cover functional things, and it still doesn't cover functional things like databases, like telephone listings, which are factual, or even maps, as long as they're accurate, just representations of facts about the way the world is arranged, the way roads are arranged. Copyright used to not cover things that are functional, like software code, because software code is really just instructions that when you embed them in a computer, make it into basically a new machine, which is why you can get patents on software because it's functional. Now, that should be taken out of patent coverage, but it should not also be patent coverage and also copyright coverage. So copyright should not apply to software at all. Software code or because it's functional. It should only apply to expressive works, artistic works like paintings or music. And in fact, in the beginning of the country, copyright only applied to things like music and written works. It didn't apply to software or to recorded music. There was no such thing as recorded music. Copyright scope, just like patent scope, should be reduced. This is Professor Tom Bell's proposal to return copyright back to what he calls the founder's copyright. That is, to the term, which is about 14 years, and to the scope in 1790 when the first Copyright Act was enacted. So that would be another big improvement of copyright. As I mentioned earlier, so in the beginning, up until the 1980s, when the U.S. joined the Berne Convention, to get a copyright, you had to apply for it by registering it with the Copyright Office. Just like you have to apply for a patent with the Patent Office, you don't have a patent unless you apply for it. Copyright, you used to have to put the copyright notice on your work. You had to be the author, had to be original, had to be statutory subject matter. That is an original work of authorship, fixed in the tangible medium of expression. And it had to have a copyright notice, and you had to register it. That has been abolished with the abolition of formalities under the Berne Convention. So now copyright is automatic. And there are many changes that should be made. That should be reversed, and we should go back to the pre-Berne system, where copyright is granted only if you have a copyright notice and only if you register it, and only if you pay regular re-registration fees. That would help with the orphan works problem and with the problem where we don't know who the owner is or who to even get permission from. And if you reduce the term, it would also help with that, because after a certain number of years, like 14 years, you would know that, okay, now I can copy this book or use this book. now I can make a movie out of this novel because it's only, it's been 14 years. I don't even know who the author was, but you should know who the author is. It should have to be a registration. You should be able to know who to contact to get a license, and it should expire after 14 years or some shorter term. So you should have to register for a copyright instead of having it granted automatically. And the other problem with it right now is it automatic. There's no way to get rid of your copyright. It's automatic. You don't even have to apply for it. You just have to write it down on paper. Now you have a copyright. And there's no way to get rid of it. There should be a statutory way to get rid of a copyright. You should be able to sign something saying, I hereby waive my rights to all my copyrights, which would be solved if you had to apply for it in the first place. But since you don't have to apply and it's automatic, you should at least have a way to get rid of your patent. There should be a way to opt out of the patent system. There's not even a way. So I think you should improve the copyright system by, number one, requiring it to be opt-in. That is, you don't have a copyright unless you opt into the system by filing for a copyright registration and putting a notice on your work. And number two, you should have an easy way, if it's not going to require registration, there should be a way for you to waive your copyright easily. There's just no way right now. It shouldn't be an inalienable right that you're unable to waive. You should be able to get rid of it. Also, the DMCA, the Digital Millennium Copyright Act, criminalizes things that are not even copyright infringement. They're not copying. They're not copyright infringement. But if you have technology that can be used to circumvent copy protection techniques, even if you do it when you have the right to, that is illegal. That should be abolished. The DMCA should be abolished. Also, the 6 strikes thing, where companies like YouTube get millions of takedown notices every day because there's no cost to an alleged copyright holder filing a removal strike. And YouTube and other companies are forced to take down allegedly infringing content, because if they don't, they lose their safe harbor of immunity granted under the DMCA, which says that you only have, if you don't have the safe harbor, then not only is the alleged infringer potentially liable, but so is the company that contributes to that by hosting it. So if someone posts a comment on someone's blog, and that includes copyrighted content, then not only can that person, who is usually often anonymous, liable, but so is the host under contributory or secondary or vicarious liability, which shouldn't be the law. And the DMCA tried to restrain that a little bit by saying, okay, if you're the host, you're not liable as long as you take down the content if you're given a notice by a holder. But so everyone adopts this policy where we just take it down to avoid, so that we maintain our safe harbor. So they shouldn't have to do that, because that leads to abuse where, again, millions of takedown notices are filed every day. You should have to prove someone's an infringer, and it should only be against the infringer, not against someone who's passively hosting it on a blog or a YouTube comment section or YouTube hosting the videos. So that should be eliminated. And one of the worst things about copyright is you don't have to prove damages if you're the copyright holder. All you have to do is register your copyright, which you do right before you file a copyright infringement lawsuit. And if you do that, then you can, as an alternative to suing someone for damages, which might be trivial, right? You sue them for statutory damages, which is like tens of thousands of dollars per infringing work, which can lead to millions of dollars of damage for just a few copies of some work. That should be eliminated. In fact, I believe that violates the Eighth Amendment and other clauses of the Bill of Rights, because it's like cruel and unusual. It's like excessive fines. You can't make someone pay $100 million for just making one copy of a Harry Potter book when the damages are like $12, right? So it should be actual damages, not statutory damages. Statutory damages should be eliminated. The fair use defense is vague. There's 4 factors, which says that you have a defense to copyright infringement if you're copying something which is facially copyright infringement because it's literal copying. You have a defense which is fair use. But fair use is nebulous. There's four factors which are not exclusive. The statute defines four factors that a court can look at. But of course, you have to go to court to prove it in every case, and that's expensive. And so a copyright bully can extort you or chill your speech, because if they just threaten you with copyright infringement, you're going to back down because there's a threat of statutory damages if you lose, and you don't know how the court's going to decide on these fair factors. So the fair use factor should be not a defense, it should be an absolute right to copy, and the burden of proof should be on the copyright holder to prove that you infringed and to prove that you committed, you caused them damages, and they should have to be actual damages, not enhanced damages and not statutory damages. That would be another big improvement to copyright law. And other improvements could be made, like putting in the fair use defense affirmative defenses for incidental uses, like, if you have a documentary or a movie where there's an architectural work or a building or something or a painting in the background which has a copyright on it, then that you can't be accused of copyright infringement for that. And that would greatly enhance people's freedom to make documentaries or to have, just everyday background scenes in the background of movies. And the U.S. should exit the Berne Convention in order to do this, because we would be in violation of the Berne Convention if we got rid of statutory damage. I'm sorry, if we got rid of the automatic registration and things like that. If we re-implemented formalities should be re-implemented for copyright, and the Berne Convention should be exited. So should other IP treaties, like for patents, the Paris Convention and the Patent Cooperation Treaty. We should leave those treaties if we need to make the reforms I proposed. Those are the big two. There are some other proposals I've made for, like, trademark. Trademark we should get rid of for trademark. Most people think trademark is about stopping consumer fraud, which is not true. To hold someone liable for trademark infringement, you don't have to prove fraud. In fact, if there's fraud, we already have law for that. That's called fraud law and contract law. So what trademark law does is it gives the trademark holder basically a property right in their reputation, which you can see because the trademark law has been amended in recent decades to add an anti-dilution defense, which means you don't have to prove that a consumer is confused or defrauded at all. You just have to prove that the value of the trademark held by the applicant is diluted or tarnished. So that should be abolished. The anti-dilution cause of action should be abolished. And trademark should go back to what it used to be under the common law, which is you can only stop someone from using a trademark in the case of consumer confusion. And that standard should be increased not from confusion, but to fraud. Of course, if you do that, you don't need trademark law because you have fraud law already. And also, the trademark law doesn't require you to prove any consumer is even confused, even if that was a standard, which is a lower standard than fraud. If you could say, there's damage to my trademark, there's damage to me as a trademark holder if someone sells a good that is confusingly similar to mine, you should have to prove that consumers are actually confused, not that there's a likelihood. So right now the law requires you to prove a likelihood of consumer confusion. And because of this, a company like, let's say, Chanel or Dior or Louis Vuitton, who sells purses or luggage, things like that, they can have counterfeit products seized, or Rolex watches, things like that. They can have these products seized even if they're knockoffs and the consumer buying the knockoff fully knows that they're buying a knockoff. So they're not confused at all. There's like zero likelihood of confusion because they know that there's no confusion. So the trademark law should not allow the trademark holder to stop counterfeit goods from being sold to consumers when the consumers know that they're counterfeit, because there's no fraud there at all. There's no confusion even. So trademark law should not be based on the likelihood of confusion. It should be based upon only actual confusion of an actual consumer. And then, of course, that means that the one who should sue the seller of the counterfeit good should be the consumer who bought it. If they're defrauded or confused, they should have a cause of action, not the trademark holder. Right now, the trademark holder has the right to sue. That makes no sense because the alleged victim of the confusion caused by selling a confusingly similar knockoff good is the alleged consumer. But if the consumer is well aware that they're buying a knockoff, no one's rights are being violated whatsoever. There's no fraud, there's no consumer confusion, there's no likelihood of consumer confusion. So those would be good, reasonable improvements of the patent, copyright, and trademark system. There are other changes we could make for other laws like trade secret law, but they're too arcane to get into. And in fact, defamation law, which is not usually considered to be a type of IP right, but I've argued in my writing that it is really a type of IP right because like trademark law, defamation law protects the right to someone's reputation. Defamation law should be radically scaled back as well. In fact, I would say if you rank the IP systems in order of damage done to the free market and property rights and competition and people's liberty, the number one most damaging IP right would be the patent right because it reduces innovation and impedes the wealth and progress of the human race and kills people. Number two, the copyright system because it heavily distorts culture and it threatens freedom of speech, as you can see with all the website takedowns and all the takedowns of content on YouTube because of copyright strikes. So copyright is number two on the list. Those two are huge because free speech is very important as one of the tools we have to get information and to spread information and to fight the government and to keep internet freedom. And the internet is an essential tool to keeping an eye on the state. So copyright and patent are the two biggest, most damaging types of IP. So those reforms are the most important. The next most damaging would be defamation. Defamation chills free speech and is absurd and outrageous. And the fourth most damaging would be trademark. And then the fifth would be trade secret and other smaller ones most people haven't heard of, like the semiconductor mask work protection and database rights in some countries, and moral rights, which are like an adjunct to copyright. But make those changes to the big changes to patent and copyright and defamation and trademark, and we would have a much less egregious and harmful IP system.